Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Imagine a world where the laws and policies that shape our lives aren't just crafted to react to existing problems, but are fundamentally designed to anticipate them. A world where, the human impact of legislation isn't some abstract afterthought, but a central driving force in its very inception.
Right.
That might sound a bit like a utopian vision, but it's the core idea behind a groundbreaking framework we're diving into today.
It is, and what's really revolutionary about that isn't just the idea of foresight itself, but doing so with this quantifiable, almost engineering-like precision.
Yeah, that's the bit that grabs me. It forces a new level of accountability into policymaking, doesn't it?
It really does. It tries to take the guesswork out of good intentions and introduces like a data-driven mirror to a policy's potential blind spots before they cause harm.
Okay, so let's get into it. Today, we're taking a deep dive into something truly innovative: policy and legal failure mode and effects analysis, or PL-FMEA for short.
That's the one. And look, this isn't just some academic concept gathering dust on a shelf. It's a remarkably practical, structured approach.
For evaluating draft policies before they're even enacted, right?
Exactly. Its mission, fundamentally, is to proactively prevent those unintended negative consequences we always seem to be dealing with after the fact. And crucially, to actively foster more equitable governance.
Oh, okay. That's a big promise. A really big promise. So let's really unpack it. We're going to explore PL-FMEA's core mechanics, including its truly unique focus on societal impact through a concept it calls affectability.
Which we'll definitely get into.
Yeah. Then we'll step into the messy, sometimes hopeful world of policy creation with two compelling case studies. First, we'll look at a hypothetical Freelance Worker Tax Incentive Act designed for India.
A really illustrative example.
And then we'll analyze real-world considerations for modernizing India's actual patent laws, which is a fascinating area.
It really is. Our mission here is to reveal how this preventative lens, this PL-FMEA approach, can lead to smarter, fairer, and ultimately more effective policies that truly serve all of us, not just some of us.
It's about building foresight directly into the legislative process, isn't it? Aiming to make policies robust enough to stand the test of time, and importantly, societal impact. Understanding PL-FMEA, a proactive approach to policy design.
So where does this idea even come from? PL-FMEA sounds pretty technical, and, well, that's because it has its roots deep in the world of engineering.
Right, I was picking up on that. So it's adapted from something else.
It absolutely is. Its foundation is something known as traditional FMEA failure mode and effects analysis. For decades, FMEA has been an incredibly well-established, almost indispensable methodology in fields like engineering and complex systems design.
Like building airplanes or cars, stuff where failure is really not an option.
Exactly. Think about the aerospace industry, automotive manufacturing, even developing intricate software systems. The core purpose of FMEA in these domains is profoundly proactive. It's to systematically identify every conceivable way a system, a design, or a process could potentially fail before it's even deployed in the real world.
Wow. So you're anticipating everything that could go wrong.
You're trying to. It's about anticipating catastrophic malfunctions or even just minor glitches and mitigating those risks up front, rather than just reacting to them after an expensive or worse, dangerous failure occurs. It's truly about prevention over cure.
So it's like a pre-mortem, you could say. Before you even build the car or launch the software, you sit down and try to break it. Look at all the ways it could possibly go wrong. Every single screw, every line of code.
That's a fantastic analogy, yes. You're trying to break it before it breaks you, essentially. In traditional FMEA, you assess potential failures based on three core dimensions.
Okay, what are they?
First, severity. How bad would the failure be? Is it a minor inconvenience, or does it lead to complete system collapse, or even loss of life in some context?
The impact level.
Then, likelihood, often called occurrence. How probable is it that this particular failure will happen? Is it a rare, one-in-a-million event, or something that's likely to happen regularly under certain conditions?
Okay, probability. Makes sense.
And finally, Detectability.
Mm.
Once a failure does occur, how easy would it be to identify it? Is it immediately obvious, like a warning light flashing? Or would it be hidden deep within the system, only discoverable after significant damage is already done?
Ah, okay. So severity, likelihood, detectability.
Exactly. And these three factors are then typically multiplied together to give you what's called a risk priority number, or RPN. That number basically tells you how much attention, how much resource you need to pay to that specific potential failure mode.
But policies aren't machines, are they? They're about people, societies, economies, complex, shifting social dynamics. So how on earth do you adapt something designed for a physical system with nuts and bolts and circuit boards to the complexities of public policy and legal frameworks? That sounds like trying to fit a square peg into a very, very human round hole.
And that's precisely the crucial adaptation PL-FMEA undertakes. It borrows this fundamental preventive lens, this way of thinking, and applies similar principles, but with a critical understanding of the very different domain.
Okay.
The key here is recognizing that policy failures are distinctly different from mechanical breakdowns. They don't manifest as a bolt coming loose or a circuit blowing.
No.
Instead, policy failures are typically, as the framework describes them, social, economic, and legal misalignments.
Misalignments, that's an interesting term.
It is. And these misalignments can harm populations, often disproportionately harming vulnerable ones, or they can lead to systemic inefficiencies across society that drain resources and, frankly, erode public trust.
And here's where it gets really interesting, because this adaptation brings a crucial shift in the methodology itself. You mentioned traditional FMEA uses severity, likelihood, and detectability, how easy it is to spot a failure. But PL-FMEA swaps that last one out for something else entirely, right?
That's right. This is truly the key innovation of PL-FMEA, and it speaks directly to the human element, the societal impact of policy.
So what is it?
Instead of detectability, PL-FMEA introduces affectability.
Affectability, okay.
The rationale is quite simple, but really profound. In the policy and legal domain, detectability, how easy it is to identify a failure once it occurs, is often incredibly difficult to measure consistently. And perhaps more importantly, it's frankly less relevant to the proactive design process.
How so?
Well, our primary concern isn't just knowing if a policy flaw exists, but understanding its potential human cost, the scale of that impact, and crucially, who it disproportionately impacts.
Right. The consequences matter more than just spotting the error after the fact.
Exactly. This signals a fundamental philosophical difference, tailor-made for analyzing the real-world impact of law and policy. It shifts the emphasis from technical fault-finding towards a much more human-centric risk assessment.
Okay, so if detectability is out, what are the new 3 pillars of PL-FMEA risk assessment, explicitly tailored for policy design?
So the first two remain quite similar to traditional FMEA in concept, but they're critically contextualized for policy. First, we still have severity S.
Right.
This is defined as the intensity of harm that would occur if a particular policy failure mode manifests. Like traditional FMEA, it's typically scored on a standard scale, say 1 to 10.
Where 10 is catastrophic.
Exactly. 1 being negligible harm, 10 signifying truly severe negative consequences. For instance, in a policy context, severe harm could mean widespread economic exclusion for a large demographic group, systemic rights deprivation for a minority group, or maybe even sparking social unrest.
That makes sense, but scoring severity in policy must be tricky, right? It's not like measuring stress on a metal part. It seems more subjective.
It absolutely is. Predicting indirect consequences, ripple effects, that's challenging. So a robust PL-FMEA process usually involves diverse expert panels, lawyers, economists, sociologists, community reps, and often relies heavily on qualitative assessments, which are then calibrated to that numerical scale through, hopefully, consensus.
Okay, so it's about the depth of the negative outcome arrived at through expert discussion. What about the likelihood of that outcome actually happening in the real world?
That brings us to the second pillar, likelihood, L. This is defined simply as the probability that the failure will occur within the given policy or legal context.
Also scored 1 to 10.
Yes, again, typically 1 to 10, where a higher score indicates a greater probability of that specific failure mode happening. Assessing likelihood in policy, again, can be complex because human behavior and societal reactions are, let's face it, less predictable than mechanical tolerances.
Definitely.
So this might involve looking at historical data from similar policies tried elsewhere, consulting with expert judgment from specialists in relevant fields, or deeply considering contextual risk factors.
Like what kind of factors?
Things like the complexity of the proposed policy itself, the existing social infrastructure needed for its implementation, or even current public sentiment or political realities. For instance, a policy requiring high digital literacy might have a much higher likelihood of failure in a region with known low internet penetration or an aging population.
Right. The context is everything.
Okay.
Severity and likelihood. And now for the new kid on the block, the star of the show for PL-FMEA, Affectability A. You called it the key innovation and the most significant adaptation. What exactly is it, and why is it so profoundly significant for how we think about and design public policy?
Affectability is indeed the defining characteristic of PL-FMEA. It's the dimension that truly elevates it beyond just a risk management tool into potentially a framework for ethical and equitable governance.
Okay, define it for us precisely.
We define it precisely as the degree to which a particular failure mode negatively impacts a broad or vulnerable segment of the population.
Okay, so it's got two parts, breadth and vulnerability.
Exactly. It explicitly measures both the size and the vulnerability of the affected population, also typically on a scale of 1 to 10. A score of 10 would mean a failure mode is predicted to impact a very large and highly vulnerable segment. Think of a policy harming a large low-income community, or a particularly marginalized ethnic group, or people with disabilities.
So it's not just how bad it is, severity, or how likely it is to happen, likelihood, but critically, who it hits, how many of them it hits, and how resilient they are likely to be to that impact.
That's exactly. Affectability fundamentally shifts the focus of risk assessment. It moves away from the technical ease of identifying a failure and zeroes in on the scale and vulnerability of the people who could be negatively affected.
And that feels crucial.
It is, because it directly addresses the critical, often overlooked concern that policy failures frequently manifest as these social, economic, and legal misalignments. And history shows these failures have a tendency to disproportionately harm vulnerable populations, the very people who often have the fewest resources to adapt or recover.
So affectability ensures that the potential human cost is central to the risk evaluation. It forces policymakers to look beyond just efficiency or legal tidiness and directly at the human impact.
That's the goal. It forces that consideration. And this has a powerful ethical and societal focus, as you said. It really sounds like it forces policymakers to confront the human element head-on, almost acting as a moral compass for legislation.
Yeah, a moral compass built right into the analysis.
Absolutely. It serves exactly that function. By being incorporated as a multiplicative factor in the overall risk calculation, which we'll get to, affectability ensures that failure modes with the potential to impact large or vulnerable populations receive higher priority for mitigation.
Even if their severity or likelihood alone might not place them at the very top of the list.
Exactly. Maybe a failure isn't that likely or that severe in isolation, but if it hits a million vulnerable people, affectability bumps its priority way up. This strengthens the moral and social accountability of the framework. It compels policymakers to explicitly consider human impact and promotes what the proponents call equitable governance.
So it's about designing policies that truly prioritize the well-being of all citizens, especially those most susceptible to adverse effects. It makes equity not an optional add-on, but a structural consideration baked into the policy's DNA from the start.
That's the ideal, yes.
So once you've scored severity, likelihood, and this crucial affectability for a potential policy failure, how do you put it all together? How do you get a clear, comprehensive picture of the overall risk? That's where the risk priority number, or RPM, comes back in, right?
That's right. The core RPN calculation in PL-FMEA is elegantly straightforward, but incredibly powerful. Simply RPN equals severity S, likelihood L, affectability A.
Multiplying the three scores together.
Yes. This multiplicative approach provides a composite risk score, a single quantitative measure of the overall risk associated with each identified policy failure mode. A perfect storm, where a failure is extremely severe, say a 10, highly likely, a 10, and impacts a vast, vulnerable population, a 10, would result in a maximum RPN of under 1,000.
So if a failure mode scores high across the board, high severity, high likelihood, and high affectability, it's going to have a really high RPN. What does that mean for decision makers? Does it become like a non-negotiable red flag?
Pretty much. The RPN's crucial purpose is to systematically rank and compare the risks associated with all the different potential policy failure modes you've identified.
So you get a ranked list of potential problems.
Exactly. Higher RPNs indicate a greater overall risk, and therefore signal an urgent need for policy reform and prioritization for mitigation efforts during the drafting phase, before the policy ever sees the light of day. It's a clear, quantifiable signal saying, hey, focus here. This is where you need to put your immediate attention, your political capital, your limited resources.
It moves the discussion from just abstract concerns or gut feelings to data-informed imperatives.
Right. Imagine a policy debate where instead of just qualitative arguments back and forth, you have a numerically backed consensus, or at least a clearer picture, of which potential pitfalls are truly the most dangerous based on severity, likelihood, and affectability.
So it's more than just a number. It's a strategic guide for where to put your energy and how to allocate resources effectively.
Exactly. The RPN offers a data-informed basis for decision-making and a clear guide for resource allocation, ensuring that efforts are concentrated where they'll have the most significant impact on reducing real-world risk and harm.
And you mentioned tracking improvement.
Yes, that's another key benefit. It also allows for tracking improvement after amendments are made to the draft policy. You can recalculate the RPN for a specific failure mode after implementing changes to a provision to objectively see if the risk score has effectively been lowered.
So you can measure if your fix actually worked.
Precisely. This structured, quantifiable approach helps prevent those unintended negative consequences, making policy design less about guesswork and hoping for the best and more about measurable improvement. It could even, potentially, fundamentally change the lobbying process, as different stakeholder groups can now point to quantifiable risks in proposed legislation, adding a new layer of objective argument to political discourse.
Yeah.
2. Case study. Deconstructing the Hypothetical Freelance Worker Tax Incentive Act, 2025.
Okay, now that we understand the mechanics of PL-FMEA, severity, likelihood, affectability, RPN, let's bring it to life. Let's make it concrete with a compelling, albeit hypothetical example. We're going to deconstruct the Freelance Worker Tax Incentive Act 2025, which was envisioned as a significant piece of legislation to support the burgeoning freelance economy in India. What was the policy's sort of noble intent, and what did its initial design look like on the drafting table?
Well, the Act's intent was indeed commendable. It aimed to provide much-needed tax incentives and formal recognition for freelance workers, which, as you know, is a rapidly growing segment of the Indian workforce. A good goal.
Seems reasonable.
However, its initial Section 3 eligibility criteria had some very specific, and as our PL-FMEA analysis later revealed, deeply problematic design elements baked right in.
Like what? Give us the specifics.
For example, to qualify for these benefits, an individual had to earn over 75% of their total income from digital freelance work. Okay. But critically, this income had to be received exclusively through digital transactions, bank transfers, online platforms, etc., and supported by tax-compliant digital invoices.
Wow, okay. Very prescriptive.
Very. Also, the individual couldn't have any formal employment or salaried payroll income during the financial year, so no hybrid work. And their total annual gross income couldn't exceed 10,000, about 10 lakh rupees.
Okay, so a well-intentioned policy aiming to support a modern workforce, but perhaps with some quite rigid, maybe untested assumptions baked into its initial draft about how that modern workforce actually operates, especially across diverse regions and income levels in India.
Exactly. So the PL-FMEA mission here was to apply this framework to that initial draft, to really stress test it, to identify specific weaknesses and structural blind spots, thereby proactively preventing potential issues before the policy could be enacted and inadvertently cause more harm than good.
And did it find things?
Oh, yes. The analysis quickly unearthed some significant flaws, each with its own calculated RPN, which gave the policymakers in this hypothetical scenario a clear roadmap for intervention.
Okay, let's start with what the PL-FMEA identified as the highest-ranked risk, the absolute top red flag in this hypothetical act. That was the exclusion of cash-paid freelancers, right? What was the precise failure mode here, and how did the PL-FMEA score it, particularly on that crucial affectability scale?
All right, this one jumped right to the top. The failure mode was directly linked to that strict requirement for income to be received only via digital transactions and supported by tax-compliant digital invoices.
Which sounds modern, but
the PL-FMEA analysis highlighted that this would fundamentally economically exclude a massive segment of freelancers without reliable digital infrastructure or access to formal banking. Think about artisans, small traders, gig workers in many sectors.
Okay, so how did it score?
When scored, it received a high severity of 7 due to the potential for significant economic harm and, frankly, widening the digital divide.
Yeah.
Its likelihood was also high at 8, given the deeply entrenched persistence of cash-based freelancing in India, particularly in informal sectors, small businesses, and rural areas where digital payments just aren't universally adopted yet.
Right. Reality on the ground.
But crucially, its affectability was very high at 9. Why? Because rural and semi-urban freelancers, as well as those in the informal economy, form a significant portion of India's workforce. This group is large and often economically vulnerable.
So high severity, high likelihood, very high affectability.
Exactly. That combination resulted in a staggering RPN of 504, making it the highest-ranked risk by a considerable margin. It basically screamed, fix this first.
And the reasoning behind that huge RPN was crystal clear in the analysis. This clause marginalizes digitally excluded workers, exacerbating income inequality. As you're listening, just consider the practical implications of such a clause. How many individuals, perhaps artisans in a village you know, or small-scale service providers in a semi-urban area, or even daily wage earners who pick up odd freelance jobs, might rely heavily on cash transactions? A well-intentioned policy, designed for the modern digital freelancer, could inadvertently leave a huge, vulnerable segment of the population completely behind if it's not designed with a deep understanding of these ground realities.
Indeed, it's a classic example of a policy perhaps created in an urban, digitally connected silo without fully considering the diversity of the target population. Another significant flaw identified was the lack of clarity in freelancer definition. The original act simply, well, it lacked a clear statutory definition of freelancer.
That sounds basic, but I can see how that would be a recipe for administrative chaos and trouble down the line. If the law doesn't precisely define who it's for, how do you expect it to be applied consistently or even fairly? Who decides who qualifies?
Precisely. This ambiguity was identified as a failure mode that, quote, could lead to widespread disputes, confusion, and inconsistent application during policy execution. It received a moderate severity of 6-7. It wouldn't necessarily cause immediate physical harm, but it would lead to significant administrative burden and legal uncertainty.
What about likelihood and affectability?
The likelihood was high at 7 due to the sheer diverse and rapidly evolving nature of freelance and gig work across various industries, from graphic design to construction, from writing to informal tutoring. It's a broad church. And its affectability was also high at 8, as this ambiguity would impact a broad range of knowledge workers, creative professionals, and even traditional informal laborers who might consider themselves freelancers under some interpretation.
Giving it an RPN of?
An RPN of 336. Still very significant. The reasoning was straightforward and impactful. Without a clear legal definition, policy execution becomes inconsistent, unpredictable, and ultimately unfair for both applicants and the administrators trying to implement it.
Okay, that makes sense. Now, what about people who juggle multiple types of work? We see that a lot now, right? Someone might have a part-time salary job, perhaps for stability or health benefits, and also do freelance gigs on the side to supplement their income or explore new career paths. How did the initial draft handle them? Did it account for this really common hybrid work model?
Unfortunately, no. That brings us directly to the third major flaw identified: penalizing hybrid income freelancers.
Penalizing them? How?
The initial eligibility conditions stated, quite rigidly, that an individual must not be employed under any formal contract or on a salaried payroll during the financial year. Full stop.
So if you had any salaried income, even minimal, you were out.
Exactly. This rigid clause would disqualify individuals with partial salaried income, which, as you said, is an increasingly common and often financially sensible career strategy, especially during transitions. This rigidity was seen as significantly reducing both the flexibility and the fairness in the policy's potential reach.
How did that score in the PL-FMEA?
It scored a moderate severity of 5, as it primarily reduced economic opportunity and flexibility, rather than causing, say, severe deprivation. Its likelihood was moderate at 6, as while common, it's not universal, but certainly prevalent, as it's increasingly common during career transitions or as a strategy for financial stability. But crucially, its affectability was high at 7 because many aspiring freelancers, part-time workers, or those transitioning from traditional employment would be directly impacted.
Resulting in an RPN of?
OR 1010.
So even if it wasn't the absolute highest RPN, like the cash exclusion one, it still flagged a significant group of people, maybe hundreds of thousands, even millions, who would be unfairly excluded from a policy intended to support freelancers in general. It's a subtle but really important failure mode, affecting a vital segment of the evolving workforce.
Exactly. It highlights how seemingly small clauses can have big exclusionary effects.
Yeah.
And finally, there was an issue that, while overlapping slightly with the cash-paid freelancer problem, highlighted an even broader systemic issue: urban-centric implementation via digital-only proof.
Okay, so this wasn't just about cash versus digital payments, but the entire digital infrastructure assumption built into the policy.
Yes, precisely. This failure mode was specifically about how the almost exclusive reliance on digital transactions and digital invoices, coupled with the implicit need for reliable digital infrastructure, internet access, bank accounts, smartphones, invoicing software, inherently created an urban bias.
Making it harder for rural folks.
Exactly.
Right.
This design choice made the policy inaccessible to freelancers in regions with low digital connectivity, regardless of whether they preferred cash or not. It meant the policy fundamentally assumed a level of digital access and fluency that simply isn't universal across the vast geography and diverse population of India.
How did this one score?
This was rated with a high severity of 7 due to the systemic bias it perpetuated and its potential to exacerbate regional inequalities. The likelihood was moderate at 6, given the well-documented variable digital penetration across different regions of India. And its affectability was high at 8 because it would directly affect a substantial number of freelancers in low connectivity areas, predominantly in rural and remote regions.
Which gives it an RPN of
336.
Yeah.
Same as the lack of definition issue, highlighting its significance. The reasoning was clear. It makes policy inaccessible to regions where digital documentation and infrastructure isn't consistently viable or affordable.
Okay, so PL-FMEA surfaced 4 major potential failure points, with RPNs ranging from 210 up to a massive 504. What does this all mean in practice? How did these high RPNs, these systematic data-backed red flags, actually guide the policy's improvement in this hypothetical case? Did they force a fundamental rethink, or just, cosmetic changes around the edges?
That's the key point. These high RPN scores didn't just point out problems in an abstract way, they directly informed and led to a series of comprehensive proposed amendments. These weren't just tweaks, they were designed specifically to improve the inclusivity, flexibility, clarity, and fairness of the policy. The PL-FMEA wasn't just about identifying problems. It acted as a precise roadmap for truly impactful solutions, aiming for systemic fixes rather than superficial patches.
Okay, give us some of those key proposed changes that were a direct, measurable response to these RPNs. How did they fix the problem?
Certainly. Let's start with the hybrid workers. To directly address the penalizing hybrid income freelancers flaw, RPN 210, the eligibility criterion for income source was significantly changed. The threshold for majority income from freelance work was lowered from over 75% down to over 60%. And critically, the amended rule explicitly stated it now includes those with hybrid income profiles.
That's a significant common sense change. It allows people much more flexibility to move between different work arrangements or supplement income without being completely penalized or losing eligibility for benefits meant for freelancers.
Absolutely. It acknowledges the reality of modern work patterns. And then, to tackle the very high-risk exclusion of cash-paid freelancers, RPN 504, and the broader urban-centric implementation, RPN 336 flaws, that rigid digital-only requirement for income receipt and documentation was entirely revamped.
How so?
The amended policy stated income may now be received through digital means or verified cash receipts. And importantly, it allowed for alternate documentation protocols, things like submitting bank deposit slips, providing notarized affidavits confirming cash income, or even getting validation from registered industry bodies or local authorities.
Wow, that's a huge equitable step towards inclusivity. That really seems designed to bring those rural and digitally excluded workers into the fold, acknowledging the economic realities on the ground instead of imposing an unrealistic digital mandate. It directly tackles that massive 504 RPN.
It's a direct, robust mitigation strategy for the highest RPN risk, designed to bring potentially millions more workers into the policy's intended ambit. Then what about that vague definition of freelancer that caused so much potential confusion, RPN 336?
Yeah, how did they fix that?
To address the lack of clarity in freelancer definition flaw, a clear, formal, and legally binding definition was introduced into the Act itself. Now, a freelancer shall be defined as an individual providing time-bound, task-specific, or project-based services without a formal employer-employee contract. Simple, clear, laconic room for argument.
That removes significant ambiguity and provides a consistent legal basis for application for both the freelancers applying and the administrators processing claims. Makes sense. And finally, any adjustments to that income ceiling to keep up with economic realities, a fixed ceiling can quickly become outdated.
Good point. Yes, the annual gross income ceiling was not only raised from $10,000 into $12,000, but importantly, the amendment included a provision that it is now indexed to inflation every 3 years.
Ah, smart. Building in adaptability.
Exactly. This enhances fairness by accounting for economic changes over time and preventing the policy's benefit from eroding or becoming irrelevant in a dynamic economy.
So the overall impact of these revisions, guided methodically by the PL-FMEA scores, seems quite broad and genuinely transformative for this hypothetical act. It aims to bring rural and digitally excluded workers into the fold, accommodate hybrid work models, reduce ambiguity for both beneficiaries and administrators, and adjust to market conditions over time. It's a comprehensive approach to making a policy genuinely effective, fair, and future-proof for its intended beneficiaries. It's a stark reminder, isn't it, that simply having good intentions isn't enough. The devil truly is in the details of the policy design, and tools like PL-FMEA help you find those devils proactively. Case study. Modernizing India's patent system with PL-FMEA.
Okay, now let's shift gears. We move from a hypothetical tax act to a real-world scenario, applying PL-FMEA to a different type of legal framework, India's venerable patent system. This case study really highlights the profound challenge of, well, outdated legislation clashing with a rapidly advancing digital age. And it shows how a tool like PL-FMEA can pinpoint exactly where an established system might be breaking down or causing unintended harm.
Interesting. So we're talking about specific sections of the Indian Patents Act, which dates back to 1970, and the related patent rules from 2003. What's the historical context here? Why did these provisions, which sound problematic now, seem reasonable at the time they were written?
Well, Section 10.3 of the Indian Patents Act 1970 and Rule 16 of the Patent Rules 2003, they collectively grant the controller, that's essentially the patent examiner, discretionary power. The power to request physical models or samples to illustrate an invention being patented.
Physical models, like actual prototypes.
Yes. And you see, back in the 1970s when these provisions were originally enacted, physical prototypes were absolutely indispensable. Patent examiners genuinely needed these tangible objects to understand complex mechanical, chemical, or engineering inventions.
Why?
Well, think about it. Hand-drawn schematics were the standard way of showing things. Computer modeling wasn't really a thing yet, certainly not widely accessible. There were simply technological limitations preventing easy digital representation or simulation. For many inventions, especially mechanical ones, holding a physical model was the only reliable way for an examiner to truly grasp the novelty and the functionality.
Okay, that makes perfect sense for that era. You needed to see it, touch it, maybe even operate it. But now, fast forward 50 plus years, we're firmly entrenched in the digital age. We have sophisticated CAD software, 3D printing, rapid prototyping, advanced simulation tools, high-definition video. How does that old requirement clash with modern realities, and what are the real-world implications for today's innovators trying to get a patent in India?
That's where the digital age disconnect, as the analysis calls it, becomes painfully apparent. Today, digital tools, computer-aided design, CAD files, interactive 3D PDFs, advanced simulations, even high-resolution video demonstrations provide demonstrably more effective and efficient ways to illustrate complex inventions.
They can show things a physical model can't, right? Like internal workings or dynamic movement.
Exactly. They can convey dynamic functionality, intricate internal details, and complex movements in ways that static physical models or 2D drawings simply cannot. So continuing to rely on, or even allowing examiners to routinely mandate, physical models in this digital age can impose disproportionate cost, immense logistical challenges, and significant confidentiality risks on applicants.
Especially for whom big companies maybe can handle it, but...
Exactly. Especially for startups, individual inventors, or university researchers who might not have the resources, the workshops, or the budget of a large corporation to just whip up a physical prototype on demand.
And I remember you mentioned Rule 16 has this safeguard stating that such material is required only when necessary. But I imagine the problem is defining necessary, right? The lack of objective standards has probably led to inconsistent practices among examiners. That must create tremendous uncertainty and potentially undue burden for applicants.
Yes, spot on. That's a key finding. Despite that well-intentioned safeguard, the lack of objective standards for when a physical model is truly necessary means that the decision is often left entirely to individual examiner discretion. And this inevitably leads to inconsistent practices among examiners.
So one examiner might be fine with a CAD file, another might demand a physical model for a similar invention.
Precisely. This inconsistency creates undue financial and procedural burdens on applicants, who can never be sure what will be asked of them or why. And crucially, it heightens the risk of exposing trade secrets prematurely if a physical model of a sensitive pre-market invention is required without adequate justification or safeguards.
Yeah.
This inconsistency itself is a systemic weakness that PL-FMEA was perfectly designed to uncover and quantify.
Okay, so let's dive into that PL-FMEA analysis of these specific patent law provisions. What were the key systemic weaknesses identified through this proactive lens, and what were their RPNs indicating the level of risk?
The first, and indeed the highest-rated risk identified in this analysis, was termed unfettered examiner discretion. The failure mode here was precisely the potential for arbitrary or inconsistent requests by patent examiners for physical models, often made without detailed justification, thereby undermining the transparency, predictability, and fairness of the entire patent examination process.
So an examiner could simply ask for a physical model on a whim, or maybe just because they're used to it, even if a comprehensive digital file would suffice and be far more practical and less burdensome for the applicant. That sounds like a recipe for frustration and inequity right there.
Exactly, that's the core of the problem. This failure mode scored a severity of 7 because it erodes trust in the patent system's fairness and predictability, and imposes significant avoidable costs on applicants who might have perfectly adequate, even superior digital representations available.
And likelihood, affectability.
The likelihood was high at 8 due to the glaring absence of objective criteria or statutory constraints guiding these discretionary requests. It's likely to happen simply because the rules allow it without clear boundaries, and its affectability was rated 6. Why 6? Because while it impacts many, it particularly affects applicants in fields like mechanical engineering, consumer products, or biomedical devices, essentially any field where structural or functional dimensions are critical, but maybe not every single applicant faces this issue.
So what was the RPN?
This combination resulted in an RPN of 336, still very high, making it the highest rated risk in this specific patent analysis. The implication is clear. Without clear procedural guidelines, there's a high likelihood of inconsistent evaluation, potential misinterpretation of technical details if the model isn't perfect, or even outright rejection of digital submissions, perhaps due to examiner unfamiliarity or preference, leading to longer prosecution times and increased costs for inventors.
And when you're dealing with cutting-edge inventions, potentially worth millions or even billions, that subjective examiner discretion opens up a huge, frankly terrifying risk of confidentiality and IP leakage. This is where the core value of the invention could be compromised even before the patent is granted, right?
Absolutely. This was identified as another profoundly critical failure mode. Physical models, by their very nature, often reveal critical design features, specific material choices, or novel mechanisms that haven't been published yet and are the heart of the invention's value.
What if they're mishandled?
Mishandling, improper storage within the patent office, which might not be set up for secure prototype storage, or even outright loss of these models could allow competitors or anyone with access to reverse engineer the innovation. This could potentially undermine its novelty or commercial value before the patent is even granted, destroying the inventor's advantage.
That sounds incredibly severe. How did it score?
It scored a very high severity of 8 due to the potentially catastrophic harm to valuable intellectual property, which can represent years of R&D and millions in investment. Its likelihood was scored 5, not guaranteed to happen, but especially relevant in sectors dealing with highly proprietary hardware or sensitive technological advancements. And its affectability was 7, primarily impacting applicants in sensitive or high-tech industries like robotics, medical devices, aerospace defense, and advanced manufacturing, where physical hardware secrets are paramount.
Giving it an RPN of
280, still a very high number. This was flagged as another critical issue that directly weakens trust in the patent system's fundamental ability to safeguard inventors' rights, which is a core purpose of the patent system itself.
Wow. Okay, so we have inconsistency and confidentiality risks. What about the plain old logistical and cost burden of physical models? I imagine that can be a huge practical barrier, especially for smaller inventors, startups, or academic researchers who don't have vast corporate budgets and prototyping facilities.
You're absolutely right. This is a significant practical hurdle that disproportionately affects smaller players. Producing physical models, especially complex ones, often requires access to expensive advanced fabrication tools like industrial-grade 3D printers or specialized CNC machinery. It might require the expertise of specialist technicians and can involve substantial material costs.
So how did this burden score?
It scored a severity of 6, as it creates a direct disincentive for individual inventors and smaller entities to participate in the formal patent system altogether, potentially stifling innovation from the ground up if the cost is too high. The likelihood was rated 7 for inventions involving tangible three-dimensional components, which covers a vast array of innovations across many fields, and its affectability was 5, heavily impacting those without in-house prototyping infrastructure or significant capital, exactly the individual inventors, startups, and universities you mentioned. This effectively risks creating a two-tiered system for patent protection based on resources.
Yielding an RPN of
2 in 10. Still significant. It's not just an inconvenience, it's a potential structural barrier to entry for innovation, particularly for those outside large corporations.
So it's not just about inconvenience. It's about potentially stifling innovation from smaller players who often drive the most disruptive advancements. Now, what about the timelines for submitting these models if requested? Are they clear in the current rules?
Unfortunately, no. That leads to the next identified failure mode: undefined timelines and consequences. The analysis found an absence of clear statutory deadlines for submitting these illustrative materials if an examiner requests them.
What problems does that cause?
It can lead to significant procedural ambiguity for applicants. They might misunderstand an informal request, miss an unspoken submission window, or even worse, face the risk of their entire application being considered deemed abandoned due to an administrative oversight or lack of clarity on deadlines. It also just causes unnecessary delays in the overall examination process.
How did this score?
Its severity was 5, due to the risks of these procedural lapses and the inherent uncertainty it creates for applicants. Likelihood was 6, as this ambiguity occurs frequently in high-volume patent offices globally where clear rules aren't set. And its affectability was 6, impacting a broad group of applicants, but particularly burdensome for first-time applicants and foreign filers, who are less familiar with the nuances and unwritten rules of the Indian patent system. This resulted in an RPN of 180.
Still a notable risk. And finally, once these valuable, sometimes highly proprietary physical models are submitted to the patent office, what actually happens to them after the examination is done? Is there any clear guidance on their return or secure destruction? An inventor wouldn't want their potentially groundbreaking prototype just sitting around gathering dust in a government office, or worse, being improperly handled or disposed of.
Indeed, that's another significant blind spot identified by the PL-FMEA: no return or destruction guidance. This failure mode refers to the complete absence of clear, enforceable protocols for what happens to physical models post-examination. Do they get returned, stored indefinitely, destroyed securely? Nobody really knows for sure under the current rules.
What are the risks there?
It scored a severity of 4, primarily due to the potential loss of unrecoverable, often expensive materials for the inventor, or the risk of premature leakage of sensitive product details if the models aren't handled or disposed of securely. Likelihood was rated 7 because it is highly likely that inconsistent practices prevail in the absence of any specific instructions or established procedures. And its affectability was 5, primarily affecting those submitting complex physical inventions that are costly to produce and represent significant IP, especially if they needed the prototype back for further development or testing. Its RPN was 140.
Okay, so faced with these clearly identified systemic weaknesses, discretion, confidentiality, cost, timelines, disposal, and their quantified RPNs ranging from 140 up to 336, what were the proposed amendments emerging from the PL-FMEA to modernize India's patent system? Did this analysis really offer a concrete path forward?
Absolutely. The PL-FMEA didn't just diagnose the problems, it directly informed specific actionable recommendations. The rationale behind these proposed amendments was very clear: to strike a precise balance between leveraging the immense capabilities of modern digital tools and maintaining the procedural integrity, confidentiality, and examiner clarity that are absolutely paramount to a robust and trusted patent system. The overarching goal was clear: transition India's system towards a digital-first approach, bringing its IP framework firmly into the 21st century.
Okay, tell us about those key recommendations and how they directly address the specific problems and high RPNs PL-FMEA highlighted.
Right. First, and arguably the most significant change proposed, was establishing a digital-first compliance standard. The amendment seeks to formally recognize and actively encourage digital submissions. Things like detailed CAD files, interactive 3D PDFs, animated simulations, annotated video walkthroughs as the default and preferred mode of illustrating inventions.
So flipping the script from physical being allowed to digital being expected.
Exactly. This means Section 10(3)(a) of the Act and Rule 16(2) of the rules would be amended to explicitly list these digital files as acceptable and encouraged forms of illustrative material. This directly reflects global best practices and acknowledges modern invention workflows. And importantly, it tackles the logistical burden, RPN 210, and helps mitigate the urban bias inherent in physical requirements.
Okay, so digital becomes the expectation, not the rare exception, making the system more accessible and efficient for most inventors. That sounds like a huge step.
It is. Second, a crucial physical only if clause. This directly addresses the unfettered examiner discretion issue, which remember had the highest RPN of 336.
How does it curb that discretion?
Under the proposed amendment, requesting physical models would now be strictly restricted to exceptional cases, where tactile inspection or material evaluation is genuinely essential for understanding the core inventive concept, and digital means are proven insufficient. And crucially, in such rare instances, the controller must provide written justification outlining with specific reasons why digital representations are insufficient for that particular invention.
Oh, so the burden of proof shifts to the examiner to justify the need for a physical model.
Precisely. This would be codified in proposed Section 10(3)(b) and Rule 16(3). It ensures that requesting a physical submission becomes the absolute exception, not the norm or an arbitrary request based on preference.
That's a direct, powerful response to the highest RPN in this case study. It introduces accountability and objectivity where there was previously potentially arbitrary discretion.
Okay, what about those undefined timelines, RPN 180, that cause so much uncertainty? To fix that, a standardized timelines and extension mechanism is proposed. To eliminate ambiguity and reduce procedural disputes, the law would define a clear statutory 90-day period for applicants to submit any requested materials, digital or exceptionally physical. And importantly, an automatic one-time 30-day extension would be granted upon simple request by the applicant.
Providing breathing room and clarity.
Yes, this would be added to Section 10(3)(c) and Rule 16(4), providing much-needed predictability and fairness in the process.
And what about those vital confidentiality concerns, RPN 280, where an inventor's breakthrough could be compromised by submitting a physical model?
To address confidentiality and return protocols, the amendments propose mandating robust confidentiality measures for all submitted illustrative materials, especially non-public ones like prototypes. This includes requiring strict internal access controls within the Patent Office for any physical models. Moreover, applicants would now have the explicit legal right to formally request the return or secure documented destruction of their physical models post-examination.
Giving them control and peace of mind.
It's exactly protecting their IP. This is addressed in proposed Section 10(3)(d) and Rule 16(5).
Okay. And finally, to ensure consistency and usability with all these new digital submissions being encouraged, it's no good saying submit digitally if everyone uses different formats the examiners can't open.
Right. To prevent that, the proposal includes having the Patent Office publish guidelines for digital model format. This means comprehensive technical guidelines detailing acceptable file formats like STEP, STL, 3D PDF, etc. Necessary annotation standards, file size limits, and submission portal specifications would be officially released and regularly updated, as outlined in proposed Rule 16(6). This ensures uniformity, reduces compatibility issues, and streamlines the digital submission process for everyone involved, applicants and examiners alike.
The overall impact here seems unequivocally positive for innovators. These amendments, clearly guided by the PL-FMEA findings, directly target the identified failure modes. They seem poised to enhance transparency, minimize the burden on applicants, especially smaller ones, bolster confidentiality, and critically support India's ambition to become a global innovation hub by truly modernizing its IP system to match global standards and technological reality. It's a compelling testament, isn't it, to how PL-FMEA can drive real, tangible, and forward-looking improvements in long-standing legislation. 4. The broader impact of PL-FMEA, costs, benefits, and future governance.
And the potential utility of PL-FMEA, as we've seen hinted at in these case studies, extends far beyond just drafting new policies or amending old ones. It also has potentially incredibly significant implications for how we challenge existing laws that might be flawed, and even how we envision the future of governance itself.
That's fascinating. So, beyond drafting PL-FMEA in litigation, How exactly is it proposed as a novel tool to strengthen legal challenges against what you might call flawed statutes in constitutional and administrative litigation? It sounds like it could potentially revolutionize how lawyers argue certain kinds of cases.
Well, think about how litigators traditionally challenge laws. They rely heavily on qualitative reasoning, citing established legal precedent, crafting narrative arguments, perhaps arguing a law is too vague or arbitrary in its application, or has an unfair, unequal impact.
Standard legal practice.
Right. PL-FMEA, however, introduces a deeply structured, almost quasi-scientific, data-driven framework to this process. It proposes to deconstruct statutes into discrete, manageable components. We're talking individual clauses, specific definitions, procedural requirements laid out in the law.
Breaking the law down into its building blocks.
Exactly. Then, it meticulously enumerates potential failure modes within those components. And these failures can be classified into useful categories for legal argument. Perhaps administrative failures, example, the law is impossible to implement as written. Interpretive failures, example, the language is so ambiguous it's impossible to know what it means. Equity-based failures, example, the law disproportionately harms a specific, often vulnerable group. Or enforcement-related failures, example, the law encourages arbitrary or discriminatory application by officials.
Okay, so you categorize the flaws. Then what?
Then, crucially, each of these identified failure modes is scored using the same PL-FMEA methodology: severity, likelihood, and affectability. This process effectively converts abstract legal flaws into quantifiable risk profiles.
Wow. So instead of just arguing in court that a law is, say, vague or unfair, you could potentially present a quantifiable RPN score that demonstrates the severity of its interpretive failure, the high likelihood of that failure causing confusion, and exactly who affectability it harms most. That makes the abstract legal argument incredibly concrete.
That's the potential power, yes. It aims to make the abstract concrete and measurable.
Give us some hypothetical examples of how this might actually play out in a courtroom. How could a lawyer use this?
Okay, absolutely. Let's reconsider that hypothetical residency verification requirement statute we touched on, the one mandating benefit applicants produce 3 years of utility bills to prove continuous residency.
Right.
Using PL-FMEA in litigation, a legal team could systematically highlight administrative failures. They could present data showing inconsistent utility coverage in rural areas, making the requirement impossible for many to meet. They could score the likelihood based on demographic data. Then, they could pinpoint the equity failures, demonstrating through affectability scores how low-income and migrant populations disproportionately lack such formal documentation regardless of their actual residency status, making them highly vulnerable to this specific failure mode.
So the PL-FMEA score would quantify the discriminatory impact.
Precisely. By scoring these failure modes with high severity, denial of essential benefits, and high affectability, hitting vulnerable groups hard, it would provide a powerful data-backed foundation for traditional due process and equal protection challenges. The judge isn't just hearing an anecdote or a principle. They're seeing quantified evidence suggesting the law's real-world discriminatory impact.
That immediately makes the abstract legal argument about due process or equal protection much more concrete and relatable to real-world impact and potential human suffering. It's not just a theoretical flaw argued by lawyers. It's presented as a documented, quantified injustice based on the law's own structure.
Exactly. Let's take another example. Imagine a flat permit fee for agricultural land. If a uniform environmental permit fee is applied across all farm sizes, from a tiny family plot to a vast agribusiness operation, PL-FMEA would readily identify equity failures. It could quantify the unfair economic burden by comparing the fee to the average income of smallholders versus large corporations, leading to a high severity score for smallholders. It could also potentially find enforcement failures if, say, non-payment leads to a disproportionately severe penalty like loss of livelihood or forced sale for failing to pay an unequally burdensome fee.
Again, quantifying the unfairness.
Right. This analysis, presented with RPNs, would provide compelling, quantifiable evidence to inform legal challenges based on principles of administrative fairness, economic justice, or perhaps even rationality review.
And what about those laws that are just notoriously hard to understand or apply consistently? The ones that leave everyone scratching their heads, from citizens trying to comply to law enforcement trying to enforce.
That's where PL-FMEA could tackle issues of vagueness, for instance, in vague technology regulation. Consider a hypothetical law banning dual-use devices, but where dual use is defined only in overly broad, changeable regulatory guidance, not clearly in the statute itself.
A common problem with tech law.
Indeed. PL-FMEA would systematically point out interpretive failures due to the stark lack of statutory clarity, leading to unpredictable enforcement and allowing arbitrary interpretations by officials. High likelihood, high severity for businesses facing uncertainty. It might also identify potential administrative failures if the regulatory agencies tasked with enforcement demonstrably lack the technical expertise or resources to consistently apply such a vague rule across complex technologies. These quantified failures, especially high RPNs for interpretive ambiguity affecting a wide range of innovators, high affectability, would strongly support traditional void for vagueness and arbitrary enforcement challenges under constitutional law. It demonstrates the law is unworkable, not just in theory, but with measurable, predictable negative consequences.
Okay, so what are the main strategic advantages proponents see in using this innovative framework in litigation? And conversely, what are some of the inherent limitations or challenges you might face trying to introduce this kind of technical analysis into a traditional legal context like a courtroom?
The potential strategic advantages are significant. Proponents argue it clarifies litigation focus by systematically identifying and prioritizing the most impactful legal defects within a complex statute. It can immensely strengthen credibility by introducing quantifiable data and expert validation, moving beyond purely rhetorical or precedent-based arguments. It powerfully highlights equity implications through the explicit affectability scoring, ensuring that the human cost of flawed legislation is front and center in the legal argument. And potentially, it could even enhance cost efficiency for legal teams by allowing them to target high-impact statutory defects more strategically with their resources.
Sounds promising. But the limitations. Courtrooms aren't engineering labs.
Exactly. There are very real practical limitations and challenges. Data scarcity can sometimes impair accurate RPN scoring. Getting reliable data on the likelihood or affectability of a specific legal clause's impact isn't always easy or available. Critically, courts may be unfamiliar with technical frameworks like FEA. Judges and opposing counsel might be resistant to or skeptical of what seems like an engineering tool being applied to legal interpretation, requiring a significant educational effort by the lawyers using it. And there's always a risk of bureaucratizing litigation. If the process becomes overly rigid, focused only on the numbers, it might lose sight of the broader legal principles, human stories, or qualitative nuances that are also crucial in legal decision-making.
Okay, so it's a potentially powerful tool for legal argument. But it needs to be wielded carefully, perhaps strategically, with a clear eye on judicial receptiveness and the availability of solid data to back up the scores. Now, let's zoom out again and look at the whole picture. The comprehensive cost-benefit equation of proactive policy design using PL-FMEA. What are the immediate first-order costs for governments and agencies looking to adopt this framework? Because implementing anything genuinely new and systematic always comes with an upfront price tag in time and resources.
You're absolutely right. The first-order costs are the immediate, tangible burdens of implementation, and they shouldn't be underestimated. There are significant time and resource requirements, particularly during the early adoption phases when teams are learning the ropes.
What does that involve?
It means dedicating specific, often lengthy working sessions for mapping out policy elements, brainstorming potential failure modes, which requires creative negativity, and meticulously scoring each one on S, L, and A. This might require reallocating existing staff from other pressing duties, or, in some cases, hiring new staff or consultants specifically trained in systems thinking, risk analysis, or policy evaluation methods.
And it's not just lawyers doing this, right?
No, that's the next cost, interdisciplinary coordination. PL-FMEA isn't just for lawyers or policy wonks in isolation. As we thought, it demands cross-functional collaboration among diverse experts, lawyers, economists, data analysts, sociologists, community representatives who understand the ground reality, maybe even engineers or scientists, depending on the policy area. This inherently comes with logistical overhead, scheduling complexities, and often a necessary cultural translation between professional domains, getting everyone speaking the same language.
And the learning itself takes time.
Absolutely. There's a considerable learning curve. Existing teams need to familiarize themselves with a new vocabulary, RPN, affectability, failure modes, a new logic rooted in systems thinking, and frankly, a new, more critical way of approaching policy drafts. This requires proper orientation, practical examples, maybe hands-on workshops, and possibly ongoing support from experienced facilitators, at least initially.
And does it slow things down? In politics, speed is often demanded.
That's the final major first-order cost, potential policy delays. Incorporating this rigorous, structured evaluation step inevitably takes time. It can extend the drafting process, which might be seen politically as a significant hurdle in contexts that prioritize rapid lawmaking or responding quickly to perceived crises. There needs to be buy-in that the upfront time investment is worth it.
Those are definitely real hurdles. It sounds like a significant upfront investment in time, training, coordination, and potentially political capital to justify the slower pace. But what about the first-order benefits? The direct, tangible gains you get from proactively designing policies this way? Do proponents argue they outweigh these considerable costs?
They strongly argue that the benefits are substantial and often far outweigh the initial investment, especially in the long run. Let's tick them off. First, and most obviously, proactive risk mitigation. It fundamentally helps anticipate problems before a law is enacted, significantly reducing the need for costly post hoc fixes, embarrassing public backlash, or lengthy, expensive judicial interventions later on. Imagine the millions, maybe billions, saved by fixing a complex tax incentive before it's rolled out and then found to be massively underutilized or exploited due to unforeseen loopholes.
Avoiding the cleanup costs later.
Exactly. Second, targeted improvements. By quantitatively scoring risks with the RPN, teams can prioritize the most serious risks and strategically allocate their limited time, resources, and political capital to fixing the provisions with the greatest potential real-world negative impact, rather than getting bogged down arguing about minor issues.
Focuses the effort where it matters most.
Precisely. Third, enhanced legal clarity. The rigorous analysis process inherently exposes ambiguous language, contradictory clauses, or overly technical formulations that might confuse citizens or lead to inconsistent enforcement. This leads to laws that are inherently easier to enforce, interpret, and understand for both the public and the administrators tasked with implementing them.
And this is where affectability really shines again, isn't it? Bringing that human, equitable dimension to the forefront right from the very beginning of the design process.
Absolutely. It's arguably its most unique and valuable contribution. Fourth benefit, equity assurance. The affectability metric introduces that explicit focus on distributional consequences, pushing teams to ensure laws do not unintentionally burden the most vulnerable populations. It makes equity a non-negotiable structural consideration from the outset, not just an afterthought or something addressed by supplementary programs.
What about trust? Does this help with public trust?
Proponents believe so. Fifth, stakeholder confidence. Using a transparent, documented, systematic method like PL-FMEA can significantly strengthen public and institutional trust. It demonstrates genuine due diligence and moral foresight in governance. People are potentially more likely to trust a system, even if they don't like a specific policy outcome, if they know it has rigorously assessed potential harm to all groups.
And once you've done it once, is it easier the next time?
Yes, that's the sixth benefit. Framework reusability. Once the methodology is established within an agency or legislature and teams become proficient, the PL-FMEA framework can be quickly reapplied across new policy domains, amortizing those initial learning costs over multiple use cases and potentially accelerating the development of higher quality policies in the future.
Okay, so those are the direct impacts: fewer crises, better targeting, clearer laws, more equity, more trust, reusable process. But good policies and frameworks often have ripple effects beyond the immediate task, isn't that right? What about the second-order effects, the more indirect institutional changes that might happen within government as a result of adopting PL-FMEA more broadly?
These are fascinating to consider as they speak to broader, perhaps slower, systemic improvements in how government works. For example, we might see institutional capacity building. Legal and policy teams, through repeated use of PL-FMEA, build internal capacity for structured, critical, anticipatory thinking. This skill set can then spill over into other domains of governance beyond just legislative drafting, leading perhaps to a generally more proactive and analytical bureaucracy.
Interesting. What else?
There's potential for policy innovation acceleration. A clear, structured, analytical review framework like PL-FMEA can actually improve the quality of public and stakeholder input. If stakeholders know how policies are being evaluated for risk, they can provide more targeted, evidence-based feedback, allowing for more creative, iterative development of policies grounded in evidence, rather than policies driven solely by political expediency or anecdote.
And financially. You mentioned avoiding costs, but could it free up money?
Potentially, yes, leading to budgetary reallocation. By reducing the frequency of major policy failures, subsequent legal reversals, and the need for costly remediation programs, PL-FMEA could save significant money long-term. These savings could then theoretically be reallocated to other valuable activities like pilot programs for new ideas, better monitoring systems for existing policies, or robust evaluation units to ensure policies are actually working as intended, creating a virtuous cycle of improvement.
But it's not all positive, right? Any potential downsides to these indirect effects?
Well, one crucial dynamic to manage carefully is stakeholder engagement dynamics. While structured engagement based on PL-FMEA might increase legitimacy if the process becomes too complex or drawn out, prolonged feedback loops requiring detailed technical input could lead to stakeholder fatigue or disengagement, especially for smaller community organizations or advocacy groups without dedicated policy staff. It needs to be managed inclusively.
Right. Accessibility of the process itself matters. Okay. And looking even further out, casting our gaze towards the horizon, what are the potential third-order effects? The truly long-term, perhaps even transformative systemic shifts in governance culture that widespread adoption of PL-FMEA might catalyze. This is where the vision gets really expansive, maybe even a bit idealistic.
This is where we speculate about the most profound, almost generational changes in how government operates. Widespread PL-FMEA adoption could foster a fundamental cultural shift toward foresight within legislatures and executive agencies. It could help embed a pervasive prevention over cure mindset across government, moving beyond reactive crisis management. It could potentially transform legislative culture from one primarily focused on asserting authority and making pronouncements to one deeply grounded in design thinking, evidence-based iteration, and continuous improvement.
A different way of thinking about making law.
A fundamentally different way. There's also the potential for the export of governance best practices. Jurisdictions that successfully implement and demonstrate the value of PL-FMEA might set global examples, potentially leading to the standardization of similar foresight methodologies in international treaty processes or widespread adoption by international organizations looking to improve policy outcomes globally.
And could it create new industries?
Possibly. The growth of supporting ecosystems. As demand for this kind of analysis grows, new services, specialized software tools, and even entirely new industries, think dedicated PL-FMEA consultancies, digital platforms for collaborative risk assessment, perhaps even AI-enhanced scoring systems may emerge to support these processes. This could create new jobs and drive further innovation in governance technology, or GovTech.
That all sounds incredibly transformative, perhaps truly reimagining how governments approach their core function of making rules for society. But every powerful tool, as we know, has its potential pitfalls, its shadow side, especially when institutionalized. What's a critical consideration, a final warning perhaps, that we need to keep firmly in mind here?
A very important one, and one mentioned in the analysis. The inherent risk of procedural rigidity. If PL-FMEA is institutionalized too rigidly, or if policymakers and administrators become overly reliant on the numbers alone, ticking boxes without critical thinking, it could make governments less responsive to sudden shifts or unforeseen crises that don't fit neatly into the predefined failure modes.
The map becomes the territory sort of problem.
Exactly. Over-reliance on the metrics might inadvertently suppress crucial qualitative insights, expert intuition, or dissenting voices that don't easily translate into a numerical score on severity, likelihood, or affectability. This could make the system feel overly bureaucratic, inflexible, rather than adaptive and intelligent.
So what's the antidote?
It really emphasizes the crucial need for ongoing flexibility, perhaps maintaining a lightweight or expedited version of PL-FMEA for urgent legislation. Critically, fostering a culture of continuous learning where past PL-FMEA exercises are reviewed not just for policy outcomes, but for how the process itself worked or didn't work, and adapting the framework accordingly. Ultimately, PL-FMEA should be seen as a powerful tool to aid judgment, not replace it. It's a structured way to think, not a rigid dogma to be followed blindly.
Outro. Oh wait, that was a really deep dive. Let's try and recap some key takeaways. At its absolute core, PL-FMEA is a powerful, genuinely proactive framework. It's ingeniously adapted from decades of engineering practice, and it helps policymakers anticipate and mitigate flaws in policies before they are even enacted. It's fundamentally about designing foresight directly into our laws from the beginning.
And its unique, standout feature, affectability, is truly game-changing in the policy context. It ensures that the potential human impact of a policy, especially the impact on vulnerable or large populations, is not just an afterthought or a side consideration, but a central, quantifiable element in the policy's design and risk assessment. This critical focus elevates the ethical and social accountability of policymaking to a potentially new level.
Through its risk priority number, the RPN calculation, PL-FMEA, provides a clear, quantitative way to prioritize where the biggest risks lie. This effectively directs limited resources, attention, and political will to the most critical issues that need fixing before a policy is launched. We saw clear examples of this with the specific flaws identified and ranked in both the hypothetical Freelance Worker Tax Incentive Act and the real-world analysis of India's patent laws. It takes some of the guesswork, maybe some of the political heat, out of legislative improvement by grounding it in structured analysis.
Ultimately, PL-FMEA is more than just a checklist or another bureaucratic process. It's presented as a tool for driving systemic improvement in governance. When used thoughtfully, it can lead to more inclusive, more flexible, clear, and fairer policies. It helps governments move beyond just reacting to problems and towards proactively preventing social harm, fostering more equitable, evidence-informed governance, which feels especially crucial in our increasingly complex and rapidly changing digital age. It's about fundamentally redesigning the process of lawmaking itself to be smarter and more humane.
This deep dive has really revealed, I think, that laws and policies aren't just abstract rules handed down from on high. They are complex systems designed by people with inherent potential failure points that, if not addressed proactively, can significantly and negatively impact human lives, economic well-being, and overall societal trust. So knowing that systematic tools like PL-FMEA exist, tools designed to build in foresight and fairness right from the ground up, how might this knowledge change your own expectations for how governments design and implement the policies that shape your world? Do you now see a future, perhaps, where every significant proposed law comes with a kind of societal impact score or an RPN profile that's as publicly scrutinized as its budget line item? It certainly gives us a lot to think about regarding the future of making better law.